Happy International Women's Day. Welcome to Landmark Chamber's webinar, Bridging the Gap, Planning Pointers for Property Practitioners. We're delighted to see so many of you joining the session today and hope you find the discussion useful and informative. My name's Miriam and Stacey and I will chair today's session. I'm joined by my colleagues, Jenny Wigley, Miriam Seitler and Kimberley Ziya, who is kindly stepping in for Angeli Foster, who has a court hearing. I will formally introduce us all in a moment. To begin with, a few housekeeping points to note. Your microphones are automatically muted, so you won't need to adjust your local settings. We very much welcome questions throughout the session and we'll answer some at the end. Please submit them via the text in the Q&A section, which may be found at the top or at the bottom of your screen. We'll answer a number of questions which have already been submitted in the course of the webinar, and we'll endeavour to answer as many additional questions as possible at the end of the presentation. This webinar will be recorded and you'll receive a link to the presentation and the recording shortly after the event concludes. If your connection is lost at any point during this webinar, we invite you to rejoin the meeting by clicking the original link again. And towards the end of the discussion, we'll ask you to assist us by answering a Zoom poll. The results will be anonymous and will be used by us to help decide content for future webinars. So let me introduce today's panelists. I'm Myriam Stacey. I specialise in property law, and a large part of my practice involves property issues arising out of developments on both commercial and residential. Jenny Wigley specialises in planning and rating law and is regularly instructed to deal with planning inquiries and judicial and statutory reviews involving all types of developments, proposals and enforcement actions. Miriam Seitler is a junior property barrister specialising both in commercial and residential property disputes. And Kim Ziya is another of our junior tenants. She's built a practice across all three of our practice areas with a particular focus on property and planning, and so is perfectly placed to take part in this crossover webinar. Finally, before we get underway, let me explain the structure of our talk. Today it's in three parts. In part A, Miriam and I are going to ask Jenny and Kim a number of warm-up questions, so basic questions that we've seen crop up in the course of our property cases and which we think are the kind of questions that property lawyers often require clarity from planners. And those questions will relate to two broad subject matters. Firstly, planning applications generally, and then secondly, more specifically in relation to use classes and permitted development. So that's part A. In part B, we get more specific. We're going to ask and consider some specific scenarios based on particular cases that we've come across in the course of our practices where planning points have arisen. And then finally, hopefully we'll have some time for questions right at the end. So without further ado, we're going to move on to the general question warm-up session in relation to topic one, which is planning applications generally.
Thanks, Miriam. Okay, starting off with the general questions. They're starting easy, but they get more difficult. So starting with you, Kim, does a planning determination consider private law rights at all? So will it give any consideration at all to a restrictive covenant, a right of access or right of light?
Okay, so I think a good place to start in answering this question was with a very fundamental principle in planning law, which is that under section 38(6) of the Planning and Compulsory Purchase Act 2004 and section 70 of the Town and Country Planning Act 1990, and that's one we'll be coming back to on several occasions, planning applications have to be determined in accordance with the relevant development plan unless material considerations indicate otherwise. So what that means is that there are two ways in which private law rights might feed into the decision-making process. The first is that they might impact on what's known as the viability of a development proposed. So, for example, if there's a restrictive covenant that's likely to preclude the development from taking place and isn't going to be released by the tribunal, for instance, or by agreement, then that might affect the viability of the proposed development. And therefore, that's particularly important if you're relying on the benefits that a development is going to produce. So, for example, new housing, in order for that development to be acceptable. So that's particularly important in cases where a local authority perhaps cannot demonstrate what's known as a 5-year housing land supply, and you're going to rely on the development to fill some of that gap. The other aspect in which a private law right might be taken into account is the subject matter of those rights might form the basis of a planning policy. be that a local policy or a national planning policy that considers effects on a local area or on neighbouring amenity. So for example, noise or light or accessibility more generally. But what won't be taken into account is the fact that an individual has a particular right, and that will not be used to defeat a planning application, and it won't be determinative of the planning issues in a case. Similarly, the planning determination or the planning permission will not of itself override or extinguish the private law right that exists. So that's the sort of basic overview to that question.
Thanks, Kim. Keeping with the theme of interest, a question that I've often wondered about is whether a planning application can be made by anyone, irrespective of whether they've got an interest, or does a specific interest in the particular development site need to be shown?
Well, hi Miriam. Short answer to that question is yes, a planning application can be made by anyone. You don't need to have an interest in the land to make an application for planning permission. But you do have to notify the owners of the site, including tenants, and you need to certify that you've done so to the local planning authority. That's a strict procedural requirement. But no, you don't need an interest yourself to make a planning application.
Kim, I've never understood this. Please can you explain the difference between a full planning permission and an outline planning permission?
Okay, so very simply, a full planning permission is a decision on the detailed proposals of how a site can be developed, so the specific proposal that's put forward by the applicant. And if you're granted a full planning permission, then subject to compliance with any conditions that are imposed on that permission, no further engagement with the local planning authority is required to proceed with the development. An outline planning permission, on the other hand, is a decision about the general principles of how a site can be developed. So that will be granted subject to conditions requiring various subsequent approval of various matters, which are known as reserved matters. And reserved matters are defined in Article 2 of the Development Management Procedure Order 2015, but they are access, appearance, landscaping, layout and scale. So you can see from that you could get an outline planning permission, but with a lot of very important features of development still to be determined at a later stage.
Jenny, if an application is granted by a local planning authority, who can challenge that grant? Can anyone, and how can the grant be challenged?
Right, well, a grant of planning permission is not open to an appeal, so refusal can be appealed to the planning inspectorate. Third parties have no right of appeal against a grant of planning permission. So that's the first important point. So the merits of the decision, the planning merits of the decision are not open to challenge. That said, if you have standing, you can make an application for judicial review of the permission granted. But that would obviously be on more limited grounds, because it would only be on public law errors that you would be able to bring that application. To do so, you would need standing, which is a normal public law concept. But these days, that's a pretty low threshold. So if you've objected to the grant of planning permission, you would have standing to challenge it by way of judicial review. And similarly, quite often campaign groups for particular ecology or greenbelt or things would be able to challenge a grant of planning permission by way of judicial review, as long as they had those public law grounds.
Okay, thank you.
And the flip side of that, Kim, if planning permission is refused by the local planning authority, who can challenge that refusal and how would you do that?
So where planning permission is refused, there's a right of appeal for the applicant for planning permission under Section 78 of the 1990 Act. So this is only available to the person who applied for planning permission. In theory, a third party, so someone other than the applicant, could challenge a refusal of planning permission by way of judicial review, but that will be on narrower grounds, limited to public law grounds, the standard grounds for judicial review. And that person would, as Jenny explained, in the case of a grant of planning permission, have to establish standing under the usual judicial review tests. However, going back to the Section 78 appeal for applicants, this is an appeal on it's a very wide route of appeal, because effectively the whole of the local planning authority's decision can be reviewed by the planning inspector appointed by the Secretary of State to determine that appeal. In terms of procedure, the time for lodging such an appeal is prescribed by the Development Management Procedure Order, specifically Article 37, and that's generally going to be 12 weeks in the case of a householder or minor commercial appeal, which are both defined in that order. And other appeals, it's 6 months from the date of a decision of a local planning authority, with the exception of decisions where enforcement action has been taken or already. Effectively, the appeal will almost always be, it's an appeal to the Secretary of State, but it will almost always be determined by a planning inspector acting on behalf of the Secretary of State. And such an appeal can take 3 different forms. There are 3 different procedures, either written representations, a hearing, or a public inquiry. And which form it takes will be determined by the planning inspectorate in accordance with criteria which are published in the procedural guide to planning appeals.
It's often come across where you look at a property, you don't know whether they've got planning permission for particular use being enjoyed. How do we advise clients as property practitioners whether a particular current use has planning permission, Jenny?
Well, the first place to look, I would say, would be the planning register, which historically meant you had to go to the planning authority's office and ask to see the planning file in relation to the particular site. Nowadays, generally that's on the website, so you can look on the local planning authority's website, see if you can find the location of the site, which if there's any planning history and you have any planning reference number, you'd be able to find that quite quickly, and then you can see what planning applications have been made in relation to the site, and say if a material change of use has been granted planning permission, then you would be able to see that had planning permission. Of course, it may well be the case that there's no planning history, that this has always been a barber's shop, for example, in which case it would have, irrespective of whether an express planning permission had been granted for that use, it would have an established use anyway, an established lawful use. If it'd been in place for 10 years or more, then that will be lawful in any event because it would be immune from enforcement. But really, yes, if it's a historic use of long standing, then there shouldn't really be any issue. If it's a relatively recent use, then you need to look at the planning register and see if it's been granted planning permission. Of course, the other thing is whether it's a lawful, permitted development right, in which case it's likely to have to be lawful unless an Article 4 direction has been granted restricting those rights in that particular authority's area.
Thank you. So Miriam, I think we're going to move on to the second topic, which is more specific, permitted development rights and use classes. I think you've got a question for Kim on that.
Great. Yeah, my question, Kim, is that I know that permitted development is good news generally, but can you explain what is permitted development, and specifically, does it mean that there has been a grant of planning permission, or is it where permission is not required?
Okay, so starting again from basic principles here, under Section 57 of the 1990 Act, planning permission is required for the carrying out of any development of land. And development in that sense is defined in Section 55 as the carrying out of building operations or a material change of use, a material change in the use of the land or buildings. So, but then you've got an exception to that under Section 57(3), which is where planning permission to develop land has been granted by development order. And this is what permitted development rights are. They're effectively national planning permission granted by development order for certain types of development or changes of use. That's probably the basic. So in theory, it is a grant of planning permission, but it's a grant at a national level, subject to conditions and limitations.
Jenny, again, in terms of finding out details, where can I find out details of what is and what is not permitted development?
Well, Miriam, the short answer to that is the Town and Country Planning General Permitted Development England Order 2015 as amended, which is colloquially known as the GPDO. Mm-hmm. And that sets out all the classes of permitted development and the restrictions on that. So Article 3 of that order is what grants the permission, mm-hmm. and sets out, and then it references the schedules, and then there are some restrictions. So for example, EIA, environmental impact assessment development may not be permitted, and in certain sensitive areas the permitted development rights don't necessarily apply. And then you have the further layer, which there may be what's known as an Article 4 direction, which is a direction made by the local authority restricting rights in particular specified areas. So they may apply and negate the permitted development right that is nationally applicable.
And where do I find those?
They would be on the local planning authority's website. You'd have to look that up there. I mean, to be safe, it was worth actually probably contacting them directly and asking if any apply.
Once I've got to grips with the basics of permitted development rights, I recently found out that there's been changes to permitted development rights. So can someone give me an overview of the types of new rights that have been introduced?
Okay, so last year the government introduced via the means of 2 different statutory instruments some significant changes to existing permitted development rights. Both statutory instruments are very creatively called the Town and Country Planning General Permitted Development England number 2 and number 3 Amendment number 2 and number 3 orders 2020. So enjoy finding those. But effectively, they both make changes to the General Permitted Development Order that Jenny has already made reference to. And perhaps the most significant change is the introduction of a new right to enlarge an existing dwelling house, which previously could be done at ground level, but now it can be done by adding up to 2 stories on top of your dwelling house. And similar rights were also introduced to create new dwelling houses, so by addition of additional stories to some commercial buildings and also existing dwelling houses. These are obviously all subject to a number of conditions and limitations that you'll find in those 2 statutory instruments.
And are PD rights, but permitted development, automatic, or is there a need to make some sort of application or notify the planning authority? What's the process?
Well, it really depends very much on the particular development right in question. So some permitted development rights you can just use. There's no need to make any reference to the local planning authority in advance. So some minor developments, so for example, a fence of a certain height you can erect around a curtilage of a building without needing to apply to the local planning authority, whereas that would otherwise be operational development. Other more complex permitted development rights, particularly the ones that Kim was just talking about, do require an application for prior approval. And there's 2 types. There's an application to the planning authority as to whether local prior approval is required. And there's also some development rights which assume that prior approval is required, so you have to apply specifically for that prior approval. And in some of the more complex rights, particularly the new ones that Kim mentioned, the topics for prior approval are pretty wide ranging and include all sorts of things that would normally be considered in a planning application, like flood risk, traffic, effect on other businesses, effect on amenities, and all those matters would potentially be subject to prior approval. And once you get to that sort of level, it almost becomes like having to make a planning application. Right. But nevertheless, the principle of the development is established by the permitted development right, but then you'd have to go for prior approval to the local planning authority of those matters that are specified. But basically you have to check the order to see which rights require those sorts of applications. And
is the prior approval process shorter or longer, or does it take the same time as a planning application?
It's well, again, it depends on the particular right, but often there can be a 56-day default period. So if you make your application for prior approval on some of the rights and the local planning authority fails to notify you of their decision within that period, then you have a default right to proceed. Which opens a whole other interesting can of worms, because third parties then can be adversely affected by their interests not being taken into account, but by the local planning authority just failing to make the decision. And then I've got a case where we've got a human rights claim for damages on the basis that we're a third party and we weren't our interests weren't taken into account, but we can't overturn the grant of planning permission because it's permitted development order and it happens by default. So that's our only recourse.
Interesting. Miriam.
How can I be sure that what is proposed, so what I'm proposing to do, falls within permitted development rights?
Well, the starting point, of course, is to read the GDPO very closely. But if you're still unsure after doing that process, then what you can do is apply to the local planning authority for what's called a certificate of lawfulness of proposed use or development, or colloquially known as a CLOPD. Which is under section 192 of the 1990 Act, and that will basically confirm whether any proposed development is lawful under existing permission, whether that's express permission or permitted development rights, and the local planning authority will confirm that for you.
And use classes, what are they and how do they differ from or interact with permitted development rights?
Okay, well, just remember what Kim said. So a material change of use, the basic principle is a material change of use is development which requires planning permission. That's the basic principle. Then you have use classes, which are set out in the Use Classes Order 1987. And the basic principle in there is that if you are within a use class, so if you change use within a use class, then that is deemed not to constitute development. So you can change use within a use class without needing to get planning permission, and you're unaffected by Article 4 orders or anything else, you can just do it. And those are all set out in the Use Classes Order. How that interacts with permitted development is you then have a further layer under the GPDO, the General Permitted Development Order, which deems that certain changes of use between use classes is lawful, is permitted. Permitted development. But of course, those changes of use can be excluded by the council making an Article 4 direction. So there may be specific exclusions in the particular area. But that's the basic framework about how they interact.
Thank you.
I've got that, but now I've read on LinkedIn that there's been recent changes to use classes. So can someone update me about those?
So last year was the year of the government making lots of changes to things that Miriam had got her head around. So this is, again, another very nicely named, the Town and Country Planning Use Classes Amendment England Regulations 2020, which made various amendments to the Use Classes Order that Jenny has just described. In very high level summary, those changes were the revocation of existing Class A, which was for shops, financial and professional services, food and drink, drinking establishments and hot food takeaways, and Class D, which was non-residential institutions, assembly and leisure. There was also a modification made to Class B, and B1, so B1 business is now omitted, and B2 is only included is only B2 anymore to the extent that doesn't fall within the new Class E, which brings me to the major change, which is this new Class E, Use Class E, which covers commercial, business and services. So basically everything that would have previously fallen within Class A, D and B1 is now within one use class, which, as you can see from what Jenny described about being able to change uses within a use class, is quite a significant potential new rights introduced by that. Lots of guidance on that you can find in the National Planning Practice Guidance on when is permission required.
Thanks, Kim. So I think we're going to relieve Kim and Jenny from the quickfire questions for a moment, and we're going to move to the next part of the webinar, which is scenarios. So here we're going to try and look in a bit more detail at specific issues that have arisen from both perspectives, planning and property. Just briefly before we get to that, the questions coming in are absolutely fantastic. They're coming in thick and fast, and I'm also reassured by the fact that people have some of the same questions that I have had for many years. So keep them coming. We will try our best to address as many as we can. Great. So this is scenario A, and this arose from one of my cases, but I think could arise very frequently. The scenario is that a lease contains that usual tenant covenant requiring the tenant to comply with the Planning Acts. That's normally defined in a predictable way, the Town and Country Planning Act and other associated planning legislation. The landlord suspects that the tenant has converted the premises from a single private dwelling house to a house in multiple occupation. So the two questions really that arose in this case, I was acting for the landlord, but the question was, what should the landlord do to pursue the suspected breach of planning law? And then secondly, what could the tenant do, or what should the tenant do to protect themselves in that situation? So Kim, I don't know whether you've got any thoughts on this.
Yeah, so I guess, I mean, the first question that you've got to determine here is, has there been a breach of any relevant planning laws and therefore of the covenant? And this goes to the question that we were discussing about the interaction between the Use Classes Order and permitted development rights, because if you consider, so dwelling houses are within Class C3 of the Use Classes Order, whereas a house in multiple occupation is Class C4, up to 6 residents. And the permitted development order does, in theory, grant permission to change between those two subclasses. So you might be thinking, well, actually, there's no breach of any relevant planning law here. But I understand in your case, there was an Article 4 direction in place, which removed that planning permission, or the planning permission granted by the permitted development order, And therefore you go back to this question of, is a change from a normal residential dwelling to a house of multiple occupation a material change of use that requires planning permission under the 1990 Act? And that's going to be a difficult question. It's going to be a question of planning judgment ultimately. It's not always the case that a change between, say, class C3 in this case and C4 will be a material change of use. It's ultimately a question of planning judgment, which can leave the landlord with some quite difficult questions of whether there's been a breach here. In terms of a tenant protecting itself, that goes back to the question of the tenant could apply to the local planning authority for a certificate of lawful existing use if a change has been made already to assess whether that was done lawfully under permitted development rights or not.
So that's exactly what happened in the case that, well, the tenant tried to take that step, but that was the tenant's argument that, yes, there had been a change of use, but it had happened absolutely years ago, and therefore they would get a certificate of lawfulness. And the only point I would add to this is that I think from a landlord's perspective, it seems quite an obvious breach and superficially one that might be easy to prove because you just point to the fact that the tenant's done something and they don't have planning permission for it. But actually in practice, evidentially, in front of a county court, it can be quite difficult to get a district judge to engage in what is ultimately decisions of planning judgment and to make decisions about whether not only do you have to explain the planning law, which a district judge doesn't want to touch, but you're also ultimately asking them to make planning judgments about whether change from one thing to another is, as a matter of planning judgment, a material change of use and therefore development requiring permission. So it's just a warning, it's just a health warning about pursuing a covenant like that.
In the county court.
Absolutely. Yeah. Thanks, Kim. So should we move to scenario B?
Scenario B, one for you, Jenny. I have a number of landlord and tenant disputes which involve leases where a tenant can't make a planning application without the landlord's prior consent. And there's often no defined term in the lease as to what planning permission is, or indeed what an application for planning permission is. So arguments have arisen in my cases where as to what exactly falls within that restriction. Obviously, it's a question of construction from a pure kind of property point of view, but the planning context will inform, I would have thought, what that might mean. There was a question in the chat, for example, as to whether a pre-application was the same as an outline consent. And so I'm interested in knowing what would fall short of a planning application for the purposes of the construction of the lease.
Sure. Okay. Well, an application for planning permission, if those are the words in the lease, you'd have to look first at what a planning permission is. Now, that is defined in the Town and Country Planning Act under section 336, which is the interpretation section, as a permission under part 3 of the 1990 Act. And if you look at part 3, that includes section 70, which is the basic application for planning permission, which can be either in outline or a full application for permission. So it can be an outline with reserved matters to follow or all the detail. Those are sort of two main applications for planning permission. Mm-hmm. It's worth noting that for an application for approval of reserved matters under an outline permission is not an application for planning permission, mm-hmm. It's just an application for reserved matters. Another type of application for planning permission is what's known as a section 73 application, which is an application for developing without or with amended conditions from a previous permission. So if you have an existing permission and you want to effectively amend the conditions on it, you can make a section 73 application, but you do get a full planning permission for that. So there is also a full planning permission. And similarly, a section, I think it's 73 capital A, is an application for retrospective planning permission. And that is also a full application for planning permission. But there are quite a number of other things that aren't. So to answer the question in the chat, pre-application discussions would not be an application for planning permission because an application is a formal step which has specific procedural requirements set out in the General Management Procedural Order, which require a particular form and particular documents and plans and things that need to be included. So it's quite clear when a planning application is made rather than when just there's discussions about it with planning officers.
Yeah, and would that be the same for a certificate of lawful development? That would fall outside, presumably, an application for planning permission?
Yes, exactly. That comes in within, I think it's part 4 of the Act, rather, or I think it's part 4. So specifically not within part 3, so not within the definition of an application for planning permission. And the reason for that really is it's an application as to certainty as to whether what you're doing is lawful or what you propose to do is lawful. So whether it needs planning permission, not a decision for the local authority to grant that planning permission.
Okay, and just lastly on that, you said that Section 73 application, I didn't even know what that was before this, to vary or remove was a planning application for these purposes, but I think you can also make an application for non-material amendments, so that's a different type of application to amend, but that I think wouldn't be a planning application. Why would that be?
That's right. That's under Section 96 capital A of the 1990 Act. That's an application for a non-material minor amendment, and that is what it says on the tin. It's an amendment to an existing planning permission, unlike a Section 73, which gives you a full new planning permission. And so the Section 73 procedure means you end up with 2 permissions, your original one and your amended one, and you can still choose which one to implement. But when you do a Section 96A application, you get an amended one, so you can't go back to the previous version of it.
Okay, so the test is you get a new application.
A new permission.
A new permission,
yeah.
Right. Okay, brilliant. Thank you. Scenario C.
And this is a very common scenario and different variations of it, and a few people have touched on it in their questions. The scenario is a simple one. A property is burdened by a restrictive covenant, for example, a covenant that the property won't be used other than as a single residential dwelling house. But then the owner subsequently obtains a planning permission to develop, and that planning permission has a condition which is incompatible with the private law restrictive covenant. So for example, the planning permission has a condition that the property can only be occupied as a residence associated with business activity run from the property, or it can only be used as holiday accommodation. So the premise of the scenario is that you've got a private law restrictive covenant which is incompatible with the conditions of your planning permission. So other than trying to negotiate a release of the covenant with the owner, so a mutual agreed release, is there anything that the owner of the burdened land can do?
I think from a planning perspective, there are limited options for the owner of the land here. You have to implement the planning permission in accordance with the conditions. So there's no sort of way to say that the covenant trumps the planning permission or anything like that, as we discussed at the start of this webinar. So your only option really would be to make an application, as Jenny already mentioned, under Section 73 to seek to amend the conditions that attach to get a new permission with different conditions attached, but how likely that is to be granted will depend on the circumstances and how important that condition was to the grant of permission in the first place. So your remedies are probably more on the property field there, and I think, Miriam, are you going to talk a bit more about what those might be?
Yeah, so on the property side of things, if you can't agree a release, then you obviously do have some options or an option to get this covenant modified or discharged. And that would be under Section 84 of the Law of Property Act 1925, which hopefully a lot of our listeners will be familiar with. I think the most likely ground that you would be looking at here under Section 84 is AA, which is that the continued existence of the covenant would impede a reasonable user of the land for public or private purposes, and unless modified, the covenant impedes that user. The problem with that is that quite a tough test. Not only do you have to show that the covenant is restricting a reasonable user, that you can probably show quite easily, particularly if there's planning permission for what you are proposing to do. But the difficulty is you've got to fulfill the other limbs, and you've got to show that the restriction, so the covenant, does not secure to the persons entitled to the benefit of it any practical benefits of substantial value or advantage to them, or you've got to show that the restriction is contrary to the public interest. And you've also got to show that money will be an adequate compensation for any loss or disadvantage which that person suffers from the discharge or modification. So it really can be quite a tough test. The final point to make on that is that, again, the planning permission won't be irrelevant to that. Section 84 specifically in subsection 1b requires the upper tribunal in these applications to consider any sort of patterns for grant of refusal of planning permissions and all material circumstances. So the existence of the planning permission is relevant, but by no means determinative. And it seems like you would be looking at a Section 84 application if you have any chance of getting this covenant shifted or changed.
Yeah.
So let's move on to our last scenario before we take some questions. So this is a scenario which relates to how a third party with an interest in land affected by a planning permission can challenge it. So here, after the grant of planning permission, which was applied for by a freeholder of a development site, it's discovered that a tenant of a unit within the site has not been notified. So, for example, I had a case with it was a business park where the freeholder of the business park was reconfiguring the access as well as other parts of the development site, which included a unit which had been let to a tenant. And the tenant wasn't notified. The tenant wanted to challenge the planning permission on the basis, amongst other things, that they didn't like the reconfiguration, the access, it would be noisy, disruptive, and all the rest of it. So before going to the property angle and seeing whether what was being proposed in terms of work and such like constituted an unlawful interference with easements, they wanted to know whether there was any scope for challenging the permission. Is the planning permission vulnerable to a challenge? And I suppose it might also arise in a building where, for example, a lessee of a flat wanted to develop upwards into airspace, which was owned by a freeholder, and the freeholder of that airspace hadn't been notified. So in short, is the fact that the person with an interest hasn't been notified something that matters and can be used to attack a planning permission that's been granted or not, Jenny?
Short answer, Miriam, yes, it is something that matters, because you remember at the outset, one of the quickfire questions, I said that anyone can apply for a grant of planning permission, but there is a requirement to notify the owners, and the owners include tenants. So anyone who is an owner or a tenant has to be notified by the applicant for planning permission. And in addition to, and that's under Section 65 of the 1990 Act and Article 13 of the Development Management Procedure Order. And allied to that, under Article 14 of the Development Management Procedure Order, the applicant has to certify to the local planning authority the ownership interests in the application site, including tenancy interests, and certify that they have notified those people. And then there's a restriction on the local planning authority entertaining the application if those procedural requirements haven't been complied with. And that's under Section 327 capital A of the 1990 Act. A planning authority shall not entertain an application that doesn't comply with those requirements, which is pretty strong wording, which can give the impression that that resulting planning permission would be invalid or a nullity if it has been entertained and those procedural requirements haven't been met. But there is some case law, starting with Maine versus Swansea from the 1970s or 80s, I think, which said that it doesn't result in the planning permission being a nullity. There was some uncertainty as to whether that would prevail after the introduction of this new Section 327A, which had the strong wording about not entertaining the application. But there has been some subsequent case law which establishes that it's a matter for the court's discretion as to what the outcome is if the planning permission has been granted in those circumstances. So the court retains a discretion not to quash. So in your example, Miriam, if the business unit owner had been notified eventually, or had heard about it eventually, and had sat on his hands and not done anything about it, then he still may be able to bring an application for judicial review, but unlikely to get any relief because of the delay and because of the usual sort of tests about prejudice and delay and not having a real interest because he hadn't bothered to do anything about it for so long. But if he finds out about it, albeit late, I expect, if he acts very quickly once he finds out about it, even if it's outside the usual time limit for judicial review, I expect he may well get permission to bring it outside that time limit, given the fact that he hasn't brought it earlier, specifically the claim on, the basis on which he's bringing it, that he wasn't notified. And if he has a material interest to protect, and there is something that would have made a difference or potentially could have made a difference to the grant of planning permission, then he may well have a good claim for judicial review and seek a quashing of the permission.
And what kind of things might those be in terms of the access point? So what if I was advising him, because I suppose he's at a crossroads here, he either has to go down the planning road and try and challenge the grant of planning permission, presumably, I mean, a further application could be made in any event as a backup. But would a decision have to be taken, or view has to be taken as to whether or not he has any substantive reason to object, and what might that look like?
Well, I suppose, I mean, if he does have some substantive reason, for example, I don't know, maybe the reconfiguration of the access means that you have heavy lorries trundling past your unit because there's a more heavy industry unit down the way. And I mean, possibly, you know, commercially, if he has a good basis for judicial review, he might bring that protectively and then use it to negotiate with the landlord to reconfigure the access slightly further away, or do something that could solve his problem. So that might be the way around. But it would be a sort of, I think he would need to have some planning kind of objection to what the permission was doing, for it to be a real claim for judicial review. If it was just a technical objection, it's probably unlikely to get anywhere ultimately, but may well use it as a bargaining chip to try and sort of, you know, reconfigure something or get some advantage with the landlord.
That's good. Okay, thank you. That's very helpful. We're on to questions. I mean, there's a plethora of questions, so many questions. We're not going to have time to answer them all, but we're going to do what we can in the short time that we have left. So Miriam, do you want to pick a question?
Two more things to do before questions. Firstly, on behalf of Landmark Chambers and also the webinar audience, I just want to wish Jenny Wigley and Miriam Stacey a big congratulations, because both of them will be taking Silk this year very shortly. It's obviously a very well-deserved and significant achievement for them both, and we wish them the best of luck in their careers as Silks.
Oh, thanks, Miriam.
Thank you.
The second thing to do before questions is we want to do a poll to gauge which topic you would be most interested in for a further property planning crossover Bridging the Gap webinar. So Josh, if we could have the poll now. And whilst we're answering some of the questions, if you just want to cast your vote. So moving to some of the questions, starting firstly with this one, regarding the new Class E. If planning permission has been granted and quotes the old use classes but has not yet been implemented, can those granted uses change to other uses in Class E without amending the planning permission? And can the local planning authority use conditions to prevent this?
Yeah, so the first point on that question is that, which I didn't get into in the quick fire answer, is that the regulations which we discussed that amend the use class order to introduce Class E have some quite complex transitional arrangements that are set out in those regulations. But effectively, what the order provide, or the amended order provides, is that from the 1st of September 2020, so September last year, any land that was in use on the 31st of August for a class that would now be within Class E is treated as being within Class E. What does that mean if you've got a class going forward? Well, effectively going forwards, it will apply prospectively to any development that takes place and falls within what would now be Class E. So you don't have to, there's no need to amend the permission, I suppose is the short answer to that question. A local planning authority can, in theory, impose conditions that preclude the effects of a use class order, but they're subject to quite significant restrictions in the case law as to the requirements and the tests for a valid condition. And they have to show that it's very much necessary, and it has to be sufficiently tightly defined. So you can't just sort of generally exclude any of the use classes order. Jenny, I don't know if you had anything else that you wanted to add on that point.
I've got a question for Jenny. What's the benefit of having an application in joint names, Jenny? I mean, you might have a contract conditional on planning. The question is, the developer as buyer is making an application, however, the seller as landowner wants to be joined in. Is there any benefit in a joint application being made?
I'd say so. I'd say yes, I think so, because the identity of the applicant for planning permission matters in terms of bringing an appeal. So if you are refused planning permission by the local planning authority, there is a right of appeal, as we've already mentioned, under Section 78 to the Secretary of State, or usually the planning inspector. So if there's any uncertainty about how that contract for sale may pan out, or the timing of it, you want to make sure that you've got the right person that either person could bring the appeal against the refusal. And if you limit it to one party and then, for example, it ends up being sold to somebody else, you may have some difficulty in bringing the appeal.
Yeah, that issue actually arose in a case I was involved in just before Christmas, and it's quite complicated, where the option agreement's going to run out before the appeal potentially has been determined by the Secretary of State, and then who might have appeal rights going onwards. And it's not clear at all as to whether that can easily be assigned from one party to another. So getting involved early on is probably the good strategy.
Exactly, I agree.
We have time for one more. I think so. Kim, there was a question at 11:11. I don't want to ask you the wrong.
Let's go back to it and see which one that was.
Is there a process for allowing a third party, for example, a landowner, to continue a planning application where the original, is that this one?
That's sort of the point we've just touched on, where it's not clear whether there's a process for a third party to take over that appeal or the application itself once it's reached a certain point. So that's where the joint application is probably a good is a good idea to protect against that position.
Okay, having said one more, there's one that I want to know the answer to. If there's an error in a planning permission, how can an error be corrected? Is that too general a question?
Well, obviously it depends on the error to some degree. I mean, there has been cases where the court can rectify the plan. If it's very obvious what was intended, there can be a rectification of the planning permission. But the basic way of correcting the error would be, I think, under section 96A that we mentioned, a non-material minor amendment. If it's clearly non-material, but it potentially is misleading or unhelpful for the future, then a way of correcting it would be to make that a non-material minor amendment. And that should be fairly straightforward if everyone agrees that it is just an error.
And I suppose another possibility, it depends on the nature of the error. If it was an error, say in a condition, your section 78 appeal right also applies to permission granted subject to conditions, as well as permission being refused. So there's potential to have the conditions reviewed by a planning inspector if you thought there was an error there. There wasn't a non-material error.
And also, I mean, this touches on, again, section 73 applications that we mentioned about amending conditions. If you, and there is some recent case law called Finney and Welsh Ministers from last year, where you do have some difficulty if you're trying to amend a condition which cuts across the description of development. Then if it conflicts with the principle of development that's been granted in the description of the application, then you can't do that by way of a section 73 application. So it's really important to ensure your description of development is right and broad enough. So if you wanted to change the number of dwellings, or you wanted to change later, or potentially have the flexibility to change later the height of a wind turbine, for example, you don't want to specify either the number of dwellings or the height of the wind turbine in the description of the development. You can agree to a condition limiting it, but then you know that you can potentially amend that condition later or seek to amend it under section 73. So again, there's some sort of technical issues about where the description is, if it's in the development, if it's in the operative grant of permission, or if it's in a condition, and how you can change those by way of different procedures.
Thanks very much, Jenny and Kim. That was really useful and very insightful. Thank you to the audience for all of their questions. We will feed them in, as well as the poll results, into planning a follow-up webinar. We're just going to close the webinar by sharing the results of the poll, which I'm sure you're all keen to see, which shows a slight preference for section 106 and still. So we'll definitely bear that in mind. Thank you very much, everyone, for joining us, and have a good day.
Thank you. Bye-bye.